Hello everyone and welcome to this webinar. Today I want to speak about the doctrine of separability of arbitration agreement. I will address this subject under 5 headings. First, concept. Second, conceptual precisions. Third, foundations of separability. Fourth, consequences of separability. And fifth, global recognition of the principle. Hello. Let's start with the concept. It's convenient to initiate a topic by carrying out a terminological precision. Although the term autonomy is used to explain the relationship between the arbitration agreement and the contract to which it refers, this term suggests that these are two entities whose destinations are not linked together. Therefore, the word separability is more appropriate to explain the relationship between the arbitration agreement and the rest of the contract, also deriving important consequences of such option. In this way, the autonomy of the arbitration agreement strictly means separability, that is, the independence of the arbitration agreement in relation to the main contract, the former presenting a full legal autonomy, save exceptional circumstances, which excludes that it may be affected by the eventual disability of the latter. Note that the possibility of separating the arbitration clause of the main agreement in which it's encapsulated allows arbitrators to declare the invalidity of the main contract without the risk that their decision will also invalidate the source of their power. This character also operates in the two modes of unidocumental formalization of the arbitration agreement, as an independent agreement or as a contractual clause, because the object of the main contract is by its nature always different from that of the arbitration agreement. So there is no reason to treat differently an arbitration agreement separated from the main contract of the one that is included there. Separability immunizes the arbitration agreement against the fate of the main contract, whether it is its nullity, resolution, cancellation, novation, or its not existing itself. Consequently, the arbitrator is competent to judge any complaint regarding the existence or validity of the main contract, provided that the arbitration per se does not suffer from a cause of nullity. Next, let's talk about the conceptual precisions. Nevertheless, it's advisable to carry out some clarifications regarding the aforementioned. First, the arbitration agreement containing a contract is not just another clause of the same. In reality, we find within the same instrument a duality of agreements, which means that the parties formally unite in both agreements at the same time, conceive them as independent of each other, which implies that their duration may differ, that its executory character is its own, that the ineffectiveness of one does not necessarily affect the other, and that each constitutes a sufficient whole in and to itself. Second, it's not possible to see in the arbitration agreement an autonomous contract, given the impossibility of considering the recourse to arbitration in vacuum. In such a way, the arbitration agreement contained as a clause has as its subject the dispute that could be originated by the other clauses of the contract, that is, by the rest of the contract. It's thus possible, intellectually, to distinguish what is substantial to the obligations from what is the procedural regime of eventual controversies, which in turn justifies the separability of the arbitration clause from the rest of the contract. The arbitration agreement is then a clause, among others, in a single contract, whose accessory nature allows the resolution of possible disputes arising from it. Third, it's in this notion as accessory that separability finds both its foundation and its limits. In such a way, although it's peaceful to postulate that a contract can survive the amputation of one of its clauses, in relation to the arbitration agreement, the opposite idea arises. That is, if a clause can only survive the annulment of the rest of the contract. The answer must be affirmative if the clause is called to play, according to the will of the parties, a determining role in the pronouncement of the nullity or in the consequences thereof, provided that it is not directly reached by the vice that causes the inefficiency. In such a way, the arbitration clause must be respected if it implies the will of the parties to entrust to an arbitrator the responsibility of saying whether the main contract is valid or no. This is obvious, given that the parties usually foresee, for submission to arbitration, all the difficulties that may arise from the contract, with one of them constituting nullity. Also, on a practical level, it would be absurd to remove arbitration issues of nullity, because it would be enough for the defendant in an arbitration regarding the execution or interpretation of the contract to claim its nullity, in order to eliminate arbitral jurisdiction in favor of national jurisdiction. In this way, the arbitration clause is separable and must be separated to the extent that it helps to define the process as a result of which the fate of the contract will be regulated. That is, because it's an accessory to the substantial clauses of the contract. Fourth, the scope of separability shall be restricted to hypotheses where the refusal to give effect to the arbitration clause in solidarity with the rest of the contract would remove from the arbitration issues that the parties have wanted to submit to it. The termination of the contract due to the end of the term or because of a unilateral waiver does not end the clause, since dispute may still arise, particularly as to whether the contract actually ended, and if so, what consequences are linked to said ending. The realization of a resolutory condition or the non-execution of a suspensive condition may also give rise to controversies without affecting the arbitration clause. Likewise, and it's the most usual aspect, the alleged or confirmed nullity of the contract does not automatically imply the nullity of the arbitration agreement. Next, we'll discuss about the foundations of separability. Rearranging the ideas presented, it's now appropriate to determine below the actual foundations of the principle analyzed. First, the arbitration agreement is analytically separable and distinct from the main contract entered into by the parties. The first being related to the procedural application relating to the resolution of the conflict, while the second is related to the substantive applications related to the rights of the parties. Second, the principle of separability is consistent with the intention of the parties that all disputes arising between them be submitted to arbitration, including those related to the validity of the main contract. Such intention is expressed in the institutional arbitration, when the regulations to which the parties submit expressi verbis notes that arbitration clause is separable from the contract that contains it. Third, The principle of separability involves a practical necessity, since without it, one of the parties to the arbitration agreement could avoid the arbitral process simply by objecting to the contract in which the first one is inserted. Fourth, separability prevents the courts from having to consider the substance of the dispute in order to determine the existence of a valid arbitration agreement, which converges with the prohibition to review, on the occasion of a petition of annulment, the merits of the arbitration award. Fifth, separability is necessary to satisfy international trade requirements, since parties of different nationalities will not hire or do business unless the dispute resolution agreements are enforced in a neutral and stateless forum, despite objections to the validity of their main contracts. Now we will look at the consequences of separability. It's necessary to specify the scope of separability, which, according to its terminology, would lead us to ask ourselves when the arbitration clause should be separated from the rest of the contract so that it remains valid, as well as when such dissection becomes impossible. We can next point out some consequences of separability. First, the invalidity of the main contract does not necessarily invalidate the arbitration agreement. Therefore, an objection to the validity of the main contract does not affect the arbitration agreement, nor does it necessarily deprive the arbitrators of the competence to resolve a dispute related to such contract. In such a way, if an arbitral or a jurisdictional tribunal concludes the main contract was invalid, this does not necessarily affect the validity of the award issued by the arbitrators under the arbitration agreement of the parties. The basis of consent usually points to separability, since the fact that one of the parties commits an error on a substantial quality of the object of the contract has no relation with the will to resort to arbitration, for which reason the arbitration agreement is not affected and must be considered valid regardless of the fate of the other clauses, so that it can be determined through arbitration according to the will of the parties. Also, problems of existence or determination of the object of the main contract do not affect the arbitration agreement, nor do they occur in cases where the main contract requires an essential form, as long as the arbitration agreement meets the requirement established by the Arbitration Act. However, there are some hypotheses in which the existence of a defect that affects both the main contract and the arbitration clause causes the impossibility of their separation. This is the case of the absence of consent of one of the parties, because if the behavior of the recipient of the offer to contract cannot be interpreted as an acceptance of it, the contract is not concluded. And consequently, there is no arbitration clause contained in the offer, as well as the rest of the other clauses. Another assumption would be that of the absence of power of the signatory of the contract to conclude it on behalf of another person, which also seems to lead to a total nullity. Because if the alleged represented did not confer on the signatory the power to conclude the contract, the defect of power also extends to the arbitration clause. It would also be the case of the vitiated consent by physical or moral violence exerted on one of the parties for the purpose of signing the document, vice of consent that would deprive of value all clauses of the contract. Second, conversely, the invalidity of the arbitration agreement does not necessarily affect the main contract, which may continue to be enforced, normally before a jurisdictional tribunal, despite the enforceability of the arbitration agreement. Third, the law or substantive law that governs the arbitration agreement may be different from the law that governs the main contract, because the concept of separability implies, as a consequence, the possibility that the arbitration agreement is regulated by a different law from that governing the main contract, although in the absence of express choice of the parties, it will depend on the evaluation of the location criteria, which will generally be the same as those of the main contract, in addition to the fact that the recourse to a different law justified in theory is rarely seen in the arbitral jurisprudence. Fourth, the arbitration agreement can survive the termination of the main contract whenever the claims are filed during the term of the agreement or during the term of the specific provisions that survive the agreement. Finally, let's talk about the global recognition of the principle. The principle of separability, contained in Article 16, subparagraph 1 of the Ancestral Model Law, enjoys today a global consensus among arbitration practitioners and is accepted by most legal systems in the world. Examples of countries whose arbitration acts recognize the principle are, in Europe, England, France, Italy, Croatia, Sweden, Belgium, and Spain. In the Americas, Argentina, Colombia, Paraguay, Canada, Peru, and Uruguay. In Africa, Ghana, Madagascar, Kenya, Mauritius, and Mozambique. In Oceania, Australia, Cook Island, Fiji, and New Zealand. In the Middle East, Qatar, Saudi Arabia, Iran, Bahrain, and United Arab Emirates. In Asia, India, China, Myanmar, Singapore, Cambodia, Thailand, and Malaysia. In Eurasia, Armenia, Azerbaijan, Russia, Georgia, Cyprus, and Turkey. Finally, we must observe that even if there are some countries that do not in some way incorporate the separability principle in their legal systems, this inconvenience can be solved through the indirect application of this principle, through the subjection of the parties via institutional arbitration to the regulation of an arbitral institution that recognizes it. Thank you very much for your time.